morning, everyone, and welcome to the Greens List. Breakfast topic this morning is expert evidence, when you need it and how to get it right. And this morning we'll get some excellent advice, I think, from Matthew Stirling and Eliza Holt, both who are barristers on Michael Green's list. Matthew Stirling is a graduate of the University of Melbourne and has been at the Victorian Bar since 1991. He appears regularly in commercial matters in the Supreme Court, the County Court, and on several occasions has appeared in the High Court. He also appears before VCAT and in disciplinary matters. He has specialist expertise in the following areas: banking, including mortgages, securities and guarantees, building and construction disputes, commercial leases, corporations law, including directors' duties and insider trading, equity and trusts, insolvency, insurance contracts, professional negligence, trade practices, and other disputes arising out of commercial documents. So as you'll see, Matthew is well placed to give us some excellent advice on this very important topic in litigation. Eliza Holt has had a very interesting background. Before Eliza ventured into the area of law, she completed a diploma of Japanese at Osaka International Women's University in 1997. She then completed a Bachelor of Laws and Bachelors of Arts degrees at the University of Melbourne. Following that, she was an associate to the Honourable Justice Ryan at the Federal Court of Australia, where she gained excellent experience in trial and appellate work, including matters in the freedom of information area, human rights, equal opportunities, industrial relations, bankruptcy, corporations and migration law. Since coming to the bar, Eliza has practiced in both commercial law and administrative law. In the area of commercial law, Eliza has advised and appeared in a broad range of matters, including contractual disputes, insolvency matters, and in employment-related matters. She has a very wide practice in administrative law and has advised and appeared in judicial review proceedings in the state and federal jurisdiction. She has also undertaken merit review proceedings in VCAT and before the AAT in matters involving the Victorian Charter of Human Rights and Responsibilities, freedom of information and migration law. So again, another excellent barrister to speak on the topic this morning. So we'll start off with Matthew Stirling introducing the topic generally. Then we'll hand over to Eliza for her presentation. We'll then have a coffee break and come back with Matthew Stirling, and then there'll be time for questions at the conclusion of their seminars. Thank you.
Thank you for attending this morning. Those matters which Caroline's obviously read off the internet, when you put on your areas of practice, you try to cover the field a little bit so that you might catch something in the net, but it reads a little bit more glowingly than probably it should. And no doubt you're thinking, well, anybody that says that they're a specialist or an expert in about 20 fields, they know bugger all about most of them. And that's probably true. There are a number of very experienced practitioners here I see this morning, far more qualified than I am to speak about expert evidence and its role in litigation. What I thought Eliza and I could do, and all we really seek to achieve this morning, is to cover some of the more important aspects of evidence in the expert realm and how courts have reacted to expert evidence over the last 15 or 20 years, because although that's the duration that I've been practicing for, I think I'm right in saying that the reaction of the courts over the last 2 decades has been to not trust the face of an expert report in the manner perhaps in which they used to. What happened is that there was a case in New South Wales called McPhee and Sprowls, and any practitioner that hasn't read it, and any partner in a law firm with a number of underlings, for goodness sake, get a copy of it to your junior solicitors and articled clerks and make sure they take it onto the tram when they go home and don't waste good firm time, but take it home and read it, because in that case Justice Hayden, now on the High Court, went through an expert's report, and it was in a peculiar factual circumstance. I didn't realise how dry in the mouth you could get at 7 o'clock in the morning. It was a peculiar factual background, which was a slipping case, if I recall it correctly, and an expert had given very specific scientific evidence on matters as particular as the friction coefficient on the heel of a woman's shoe, both the sole, I take that to be the toe part, and the heel, and I think it was a high-heeled shoe, measure the friction coefficients of those two surfaces, then also measure the friction coefficient of the floor on which the woman slipped. Goodness knows how any male expert witness could condescend to such matters as women's high-fashion shoes. And he then explained why it was that the friction on all of those matters was made the floor far too slippery. Justice Hayden basically said, look, that's all very well, but your report is so highfalutin and so over-technical and confusing and difficult to follow the process of reasoning that it was not accepted into evidence, or if it was accepted into evidence, it wasn't accepted by the judge. And of course, what does that tell us? It tells us that when experts are retained, a great deal of thought has to go into what matters those experts are really called on to give evidence about. And the topics that we wanted to cover today, in no particular order, are defining the issues for expert opinion, how you might go about selecting an expert, I suppose that's pretty easy, working out what the issues are that the expert really needs to provide an opinion on and how that fits into the overall case which is at hand. And then a couple of other matters, some comments about recent cases as we go through, some comments about how you might object to expert evidence, because that too is a growing field for, I suppose, particularly for barristers. And finally, there's one other topic I think we had there, client legal privilege. That is, when there are communications with an expert and an expert produces drafts, and working documents, and there are communications on the file from the solicitor, what happens with privilege in relation to those, and how should a solicitor who's briefing and retaining an expert best protect himself? So with that at hand, we really want to do no more than provoke some thought and discussion, and to perhaps highlight to the profession that in this area, which really is treacherous, to give great thought to where the expert evidence really sits within your case, how you can then best brief that expert and comprehensively brief that expert so that his report is admitted into evidence. And then finally, of course, just because a document is admitted into evidence, it doesn't mean it's accepted as evidence or accepted by the trial judge. The final objective, of course, in calling any expert witness is to have that witness's opinion preferred over any opposing witness, or over no evidence at all, for that matter, by the trial judge. So with that in mind, I'll ask Eliza to speak first, and then I'll address some matters at the end, and perhaps we might have some time for questions at the conclusion.
Good morning. Now, there are going to be some overriding themes that will keep popping up today over and over, and as Matt has already touched upon, the two main things really that are important to take away from today is, first, how can you get the greatest benefit from your expert's report and evidence? But secondly, and I would say most importantly, in an overriding sense, is how to ensure that your expert's report and evidence in court is not undermined, that it remains objective from the perception of the court, and therefore is not only accepted into evidence, that is, remains admissible, but is given the greatest credibility and hopefully is the preferred evidence before the court, keeping in mind that where one party instructs an expert, usually the other parties will do so in response, if not briefing, at times instructing more than one expert, depending on the topics in the case. So what I shall be touching on today is the topics of selecting an expert, framing how to instruct an expert, and how to frame and define the issues. As anyone who's instructed an expert before will know, that all of these issues merge and overlap, and therefore rather than doing them one after another, I will be attempting to address it in a chronological order. So how do you go about selecting an expert? Primarily, first and foremost, you must know your pleadings, whether you're for the plaintiff or the defence. Now, this requires, at a very early stage in your case, understanding what evidence you require to call in order to prove your case. That means differentiating between lay evidence that's going to be required, and then importantly, the expert opinion evidence. The opinion evidence, now, in general, as everyone knows, opinion evidence is not admissible. However, under the Evidence Act, there is an exception, whereas a specialised opinion based, the knowledge based in training, education, expertise. When selecting, so firstly you must know your pleadings. If you've drafted the pleadings, then most likely you will have an idea, having drafted the affidavits, what evidence will be required to call, and therefore what areas you believe an expertise is going to be required. If counsel has drafted the pleadings, then probably best to go to him or her for their advice. However, the next necessary thing is, are they actually necessary? As Matt will no doubt touch upon, there have been many cases where experts have been instructed and most likely, and have often not actually offered anything to the case. They've just regurgitated the facts that are already before the case and that will already come before the court through the lay evidence. But once you've determined that an expert is required, you need to decide who. The first thing to work out is what area of expertise. Just because an expert is a civil engineer or a doctor or a lawyer, as we know, everyone has their own distinct areas of expertise, often within further areas of expertise. This is important because, as Matt touched upon, if an expert is not properly qualified or does not have the necessary qualifications within the field or on the topic that they purport to give evidence, then it may not be admissible because it may be found to fall outside of their area of expertise. How do you go about finding someone? Really, it will come down to your normal sources. Experts that you've briefed previously, speak to other practitioners, they may be able to recommend someone, or it may even come down to personal contact. Someone knows someone who has an expertise in that field. The next step that we believe is the most important prior to instructing an expert is to arrange to have a conference with the expert. Get them into your office or into barristers' chambers to discuss the matter. This is extremely important on a number of fronts. You could discuss the case in general terms and determine a number of things. Firstly, do they have, as I've mentioned previously, the relevant qualifications? Do they actually have the expertise to give an opinion on the issues that are before the court? And even prior to that, what are the actual expert issues? Just because you've drafted the pleadings and you've taken instructions from your client, you may or may not understand the actual technicalities of the issue that evidence is required upon. By inviting the expert into your office and having a conference with them, you'll be able to tease out with them and get them to explain the actual expert issues themselves. This will help not only determine whether they know anything about it, also from your point of view, you'll be able to start to ascertain what sort of evidence would they give in this case. Ask them questions about the general nature of the case, about the defence that's been put forward, about any opposing expert reports that have already been filed and served, and you could start to ascertain what the issues are and what their likely answers would be in a report. Further, by doing this, the next step before instructing the expert, you will be able to frame, from your discussion with the expert, you'll be able to start to define the issues and therefore frame the questions that are to be contained in your letter of instruction which is the next step that I shall get to, but you'll be able to actually frame the questions so that you will be able to obtain the greatest benefit from the expert by asking the right question. It sounds simple, but if you don't understand the issues that are the technicalities of whether it be electricity or quantum physics or maybe a particular type of medical evidence, whatever it may be, by discussing it with the expert, you'll actually be able to put it in the correct language, the questions in the correct language to ensure you get the answers that are necessary. Some experts, you may ask question A and they will only answer that question. They may not go further, and it may not be until you're in court that you realise that you require that extra step, but being an expert, they'll only answer what they are asked. In any event, so also another advantage of a conference, you'll be able to test their evidence and in a sense, it can almost be like a running through a cross-examination in a sense. Do be aware that any notes that you take during such a conference may not be the subject of legal professional privilege, so it's something always to be kept in mind in that regard. Once you've had the conference, then the next important step is to instruct the expert if you decide to use that expert. And there comes in the letter of instruction. This is an important document which also will be discoverable. But in that letter, you need to set out first and foremost the factual background to the proceeding, which you would have already discussed with the expert, obviously, but you need to set out clearly in the letter what the facts are to be assumed by the expert. Now, there will be some facts that aren't in dispute that can clearly be set out, but obviously there'll be facts that are in dispute. You must state clearly what assumptions may be made by the expert and to assist you in that regard, include in the letter all relevant court documents, including pleadings, but most importantly, affidavits. So affidavits of your main witnesses, which will set out the history of the matter and the facts. In saying that, do not simply peddle your client's case. There is no point making it a missive, an argument to the expert as to why your client's case is wrong, and purely putting forward the facts as your client instructs you are the case, and that's it. There's no point doing that. Why? Because under cross-examination, when the expert is asked, were you informed of X, Y, and Z, and they have to admit they weren't, it will immediately undermine the credibility and the relevance of their report. So include the relevant court documents, pleadings, and any opposing expert reports that have been received. Finally, and very importantly, with the report, you must include the relevant court form, practice note, or tribunal practice note. Everyone knows of these, but they are extremely important for a number of reasons. Firstly, if they're not included, the report may not be found to be admissible by the relevant court or tribunal, but they do set out for the expert what must be contained in their report, how they must go about it, and they must also refer in their report to the fact that they have read and acknowledge the relevant court form or practice note. The relevant Supreme Court order is Order 44. 4403 goes through what must be in the report, and the form is 44A. The new Federal Court rules include a new practice note, CM7. It was signed off by the Chief Justice on the 1st of August. So to keep that in mind, ensure that it's not the old form that you include if that's the jurisdiction that you are in. And similarly, VCAT has a practice note on expert evidence. I would actually recommend before you instruct the expert before you have the conference, to have a glance at the rules and the practice note so you yourself are across what needs to be contained in the report in case there are any questions from the expert on that. But that is very important. It seems very simple, but there's just no point missing a simple step like that and then having gone to all the effort of conferring with instructing an expert to then find that your report is not even accepted or admitted into the court's record. So once you've, and finally, in the letter of instruction, you need to frame the questions and issues that are to be addressed by the expert in his or her report. As referred to earlier, those issues and questions you may frame and tease out from your conference with the expert prior to sending out this letter of instruction. One issue that we think is important is do not offend the ultimate issue. The ultimate issue rule is no longer contained in it's been abolished under the New Evidence Act. However, no judge or bench or tribunal likes being told what they must find. When it comes to the ultimate issue that they must determine, it will generally offend a bench if an expert comes along and says, yes, I think so-and-so was negligent, or yes, the chain of causation is satisfied. Legal concepts such as those, the expert generally will probably be stepping outside their field of expertise anyway, but you don't want to risk annoying the judge or the tribunal member by doing so. However, what you can do very cleverly by having had that conference and working out how to frame the issues correctly is you can lead the horse to water. Frame the questions like building blocks so that they lead the judge or tribunal to, having no other choice, you would hope, making the decision that you want. Frame those questions so that, but the answers, which you will know what generally, you hope, from the conference, what answers will be given to those questions by your expert, so that the building blocks set up so that the court can only reach that ultimate answer that you want in that regard. That said, another helpful idea is also, do not, if useful, if necessary, provide to the expert hypothetical scenarios within the letter of instruction. So rather than say, these are the facts, can you please give your opinion on this scenario, what would be the result? If there's a possibility, and that do not just put, in other words, do not just put forward the best case scenario that your client hopes the court will find on the facts was the case. As you know, you are going to be opposed by defence, and it may be that the court does not find that that best case scenario actually existed or would exist. So give other variables. If it was in evaluation of a business case, Matt and I were discussing earlier, rather than say, please advise us to the valuation of the business based upon an increase in our client's customer base of 50%, also give the scenario of that the client base remains the same, or that it may go down by a certain percent, if there's any likelihood that the court may find that be the case. By doing so, you give yourself the options that hopefully the court will find the factual scenario that you put forward as being the best and put forward as your client's position. However, in the event that a worst case scenario is found, you haven't shot yourself in the foot by leaving yourself with no expert evidence before the court. If the court does not find the best case scenario, there's no further evidence before the court. Have other options if that is the sort of case that you have and you think that would be useful. Finally, in the report, the expert must be able to send out, as I've mentioned, all the relevant facts that they have been provided with, but all documents that they have been provided with, and the methodology that they use, in order that it be admissible, and that is in accordance with the case that Matt has touched upon of McPhee and Sprouse. The expert must also be able to state that the content of their report and their evidence is based wholly upon their specialised knowledge. If they are unable to do so under cross-examination, or indeed what they may be objected to, not only parts of their evidence, but if not the whole of their evidence. And if necessary, there is always the option, if necessary, after receiving opposing experts' reports, you may also file supplementary reports if there are issues that need to be further addressed, or in the event, and you hope this not to be the case, that your expert changes their opinion on a point or points. That is always available. I believe I've rushed through that faster than I thought I would, and that is the conclusion of my presentation.
We've got a few minutes before we have a coffee break, so I thought I'd make just a couple of observations myself about expert evidence. Eliza has spoken about the importance of framing the question in the first place and having a meeting to do so. What's also really important is not to have too many draft reports floating around, because draft reports are, of course, discoverable. And so in a difficult area of expertise, what would often be the most prudent course is, if your expert is struggling in arriving at the right question, is to have a conference with them and to verbally discuss whatever issues they have, so that you end up with pretty much the final report, because of course you don't want draft reports floating around which will be discoverable and which show that the expert has changed his mind on critical issues. So that's fairly important. The other thing that's often overlooked in expert evidence is often experts exhibit a number of documents which which they rely upon to prove their area of expertise. It might be statistics, it might be medical records or books and of things of that nature. Don't ever assume that all of those are admissible. I mean, often council reach agreement between themselves that they're going to admit all the expert evidence with the exhibits as well, but they're not just admissible because they're attached to an expert report. And you know, obviously, if a important exhibit to an expert report, such as statistics, is objected to and you can't properly prove it, then it can seriously undermine the value of the expert evidence. The other point which Matthew might sort of touch on as well is often, depending on what area of expertise the expert's giving evidence is, often they have to assume a set of facts, and it's those facts, of course, have to be proved. If the assumptions that the expert report is based on are correct, if he's going to assume a set of facts, you have to prove those facts properly. That's also very relevant. And as Eliza said, expert evidence often, where it's required in a case, can either make or break your case. So it's really important to do your work to get the right expert. I think I've probably said enough about that. So we can have a coffee break now.